Good day everyone. Assalamualaikum warahmatullahi ta'ala wabarakatuh. A pleasant day to all of you. We are the group 3 and today we will be presenting our discussion on the revised Corporation Code of the Philippines, RA 11232, specifically covering Title 10, appraisal right up to Title 16, investigations, offenses, and penalties. To formally begin, allow me to introduce myself. I am Saad Lau, and I will be discussing the first topic, the Title 10, appraisal right under the Corporation Code of the Philippines. So let us now proceed with the discussion. So, under the Section 81, the law grants stockholders the right to dissent and demand payment for the fair value of their shares when certain corporate actions could significantly affect their rights or interests. This right ensures that stockholders are protected from decisions that may not align with their best interests. So, there are three main situations where the appraisal right may be exercised. First, when the articles of incorporation are amended in a way that negatively affects the stockholders. Halimbawa nito ay kung dati ay may pantay-pantay na karapatan ang lahat ng mga shares, ngunit biglang nagkaroon ng bagong klase ng shares na may mas mataas na privilege kaysa sa mga naunang mga shares. Maaaring hindi ito pabor sa ibang stockholder. Sa ganitong kaso, maaari nilang gamitin ang appraisal right upang mabayaran sila ng patas sa kanilang shares. So, the second situation is when the corporation sells, transfers, mortgage, pledge, or otherwise dispose of all or substantially all of its assets. So, alimbawa naman po nito is kapag ang isang corporation na may maraming lupain at gusali ang nagpasya na ibenta ang halos lahat ng ari-arian nito, ang mga stockholder na hindi sumang-ayon dito ay may karapatang tumutol at humiling ng patas na nakabayaran para sa kanilang shares. So, the third situation is when there is a merger or consolidation with another corporation. So, ang halimbawa naman po nito is kapag ang isang kumpanya ay pinagsama sa isang mas malaking korporasyon at nagbago ang pamamahala at direksyon ng negosyo. Kung may stockholder na hindi sang-ayon sa pagsasanib nito, maaring niyang gamitin ang appraisal right upang matanggap ang patas na halaga ng kanyang shares at lumabas sa kumpanya. So, aside from the three main instances under Section 81, there are other situations where the appraisal right may be exercised. First, as provided in Sections 16, 37, 40, and 77, stockholders can demand payment for their shares when there are fundamental changes to the corporation's charter or articles of incorporation. Halimbawa po nito ay kung ang isang kumpanya ay magbabago ng pangunahing layunin ng negosyo nito mula sa real estate patungo sa manufacturing, maaaring hindi ito pabor sa ilang stockholders kaya maaari nilang gamitin ang appraisal right. So, the second under Section 42, a dissenting stockholder may exercise the appraisal right if the corporation decides to invest its funds in another business or for a purpose other than its primary purpose. So, ang halimbawa naman po ng second situation natin is kapag ang isang korporasyon ay nasa food industry, ay nagpasya na mag-invest sa isang mining company. Kung hindi ito sang-ayon sa layunin ng isang original na negosyo, maaring gamitin ng stockholders ang kanilang appraisal right. So lastly, under Section 105, in a closed corporation, any stockholder may demand the corporation to buy back their shares at fair value, as long as the company has enough assets to cover its debts and liabilities. So, bigyan naman po natin ito ng halimbawa. So, kung ang isang stockholder sa isang maliit na family-owned business ay nais nang lumabas sa kumpanya, maaari niyang gamitin ang appraisal right upang mapilitan ang korporasyon na bilhin ang kanyang shares sa patas na halaga. These provisions ensure that stockholders are protected from the major corporate decisions that may negatively affect their investments. So, tandaan po ninyo yun, no? Yung tatlong instances sa under Section 81, pati ito naman pong another instances maliban po doon. So, tandaan po ninyo, doon po pwede natin gamitin ang appraisal right. Now, let us discuss the limitations on the exercise of the appraisal right. First, any of the instances provided by law for the exercise of the right by dissenting stockholder must be present. Halimbawa po nito, kung walang naganap na merger, fundamental change, or bagong investment na labas sa primary purpose ng company, hindi maaaring gamitin ng appraisal right. Second, the dissenting stockholder must have vote against the proposed corporate action under Section 82, Paragraph 1. So, the right is not available to a stockholder who was either absent at the meeting where the corporate action was approved or was present but abstained from voting. So, halimbawa po nito ay kung hindi po siya dumalo sa meeting or hindi bumoto, hindi siya maaring mag-demand ng payment para sa kanyang shares. So, the third limitation is a written demand on the corporation for payment of shares must be made within 30 days after the date the vote was taken. Halimbawa po nito is kung lumagpas na sa 30 days bago siya maghahin ng demand, mawawalan na siya ng karapatan na gamitin ng appraisal right. So, kailangan hindi siya lumagpas ng 30 days para pwede pa siyang mag-demand, no? So, the fourth limitation is the price must be based on the fair value of the shares as of the day before the vote. So, halimbawa po nito is kailangan yung price po natin is nakabase sa fair value. So, the fifth is such fair value must be determined as provided in Section 82, Paragraph 2. Ang halimbawa naman po ng limitation na ito is kung may hindi pagkakasundo, maaaring magkaroon ng independent evaluation. So, the sixth limitation is about payment for the shares must be made only out of the unrestricted earnings of the corporation under Section 82. So, halimbawa naman po nito is kung walang sapat na kita ang company, hindi ito maaaring magbayad para sa shares ng dissenting stockholder. So, the last limitation is about upon such payment, the stockholder must transfer his shares to the corporation under Section 82. Halimbawa naman po nito is kapag nabayaran na, hindi na siya stockholder ng company. These limitations ensure that the appraisal right is exercised properly and fairly, protecting both the stockholder and the corporation. So, palagi po nating tandaan yung mga limitation po, no? Kung kailan hindi pwedeng gamitin si appraisal right. Now, we will be talking about Section 82 of the Revised Corporation Code, which explains how the appraisal right is exercised by stockholders. Under this section, a stockholder who vote against a corporate action may exercise their appraisal right by submitting a written demand for payment within 30 days after the vote. If they fail to do so, it will be considered a waiver of their right. Once the corporate action is implemented, the company must pay the dissenting stockholder the fair value of their shares based on the price the day before the vote. Any increase or decrease in value due to the corporate action will be not considered. If the stockholder and the corporation cannot agree on the fair value within 60 days, 3 independent appraisers will determine it. One chosen by stockholder, one by the corporation, and a third agreed upon by both. Their decision is final and the corporation must pay within 30 days. However, payment can only be made if the corporation has unrestricted retained earnings. Once the stockholder receives the payment, they must transfer their shares to the company. So sa madaling salita po, may tatlong mahalagang hakbang sa paggamit ng appraisal right. First, gumawa ng written demand sa loob ng 30 days matapos ang boto. Pangalawa, tanggap ang patas na halaga ng shares base sa presyo bago ang boto. Pangatlo, ipasa ang shares sa company matapos mabayaran. Kung may hindi pagkakasundo sa presyo, tatlong appraisers ang magpapasya at ang desisyon nito ay final na. Now, let's talk about the procedure for exercising the appraisal right as outlined in Section 82. This section provides a uniform process that a dissenting stockholder must follow to claim payment for their shares. Here are the 3 key steps. First, the stockholder must submit a written demand to the corporation within 30 days. Kailangan magsumite ng nakasulat na demand sa loob ng 30 days matapos ang boto. Kapag lumampas sa deadline, mawawala ng karapatan ng appraisal right. Second, the stockholder must surrender their stock certificate within 10 days after demanding payment. Kapag naipatupad ang corporate action, kailangang isuko ang stock certificate sa loob ng 10 days upang matanggap ang bayad. Lastly, the stockholder must transfer their shares to the corporation after receiving payment. Matapos bayaran, kailangang ipasa ng stockholder ang kanyang shares sa company. Moving on to the Section 83, the effect of demand and termination of right. Once a stockholder demands payment for their shares, their voting and dividend rights are temporarily suspended until the corporation either cancels the corporate action or completes the payment for the shares. However, the stockholder still retains the right to receive fair compensation for their shares. The stockholder is not paid within 30 days after the valuation, their voting and dividend rights will be automatically restored. Sa madaling salita po, kapag humiling ng pagbabayad ang isang stockholder, mawawala pansamantala ang kanyang karapatang bumoto at tumanggap ng dividend hanggang hindi pa siya nababayaran o hindi na ituloy ang corporate action. Ngunit kung hindi siya nabayaran sa loob ng 30 days, mababalik agad ang kanyang karapatan. So here are the effects of exercising the appraisal right. When the dissenting stockholders demand payment for their shares, 2 things happen. First, their rights to vote and receive dividends are temporarily suspended. Ibig sabihin po nito, hindi mo na siya makakaboto o makakatanggap ng kita mula sa kanyang shares habang hinihintay ang proseso. Second, they are entitled to receive the fair value of their shares. Ibig sabihin po nito, ang halaga ng shares ay maaaring mapagkasunduan ng stockholder at ng kumpanya o itatakda ng mga appraiser na pipiliin nila. Under Section 84, the main point is that once a stockholder demands payment for their shares, they cannot withdraw their request unless the corporation agrees. However, if the corporation cancels the corporate action, the SEC disapproves it, or the SEC rules that the stockholder is not entitled to the appraisal right, then, first, the stockholder's right will be restored. Second, they will regain voting and dividend rights, including any missed dividends. Sa madaling salita po, kapag hindi natuloy ang corporate action o hindi inaprubahan ng SEC, may babalik ang pagiging stockholder at matatanggap niya ang naipong dividends. Next, let us discuss when right to payment ceases. Once the stockholder demands payment for their shares, they cannot take back the request unless the corporation allows it. However, there are situations where this right is automatically lost. First, the stockholder withdraws their request, and the corporation agrees. Second, the corporation cancels or abandons the corporate action. Third, the Securities and Exchange Commission or SEC disapproves the corporate action. Lastly, the SEC determines that the stockholder is not entitled to the appraisal right. If any of these happen, the stockholder will not longer be paid for their shares. Instead, they will regain their status as a stockholder and receive any missed dividends. Moving on to Section 85, let us discuss who bears the cost of appraisal. In most cases, the corporation is responsible for covering the appraisal expenses. However, there are exceptions. First, if the appraised fair value is almost the same as what the corporation initially offered, the stockholder will bear the cost. Second, if the stockholder takes legal action to claim payment, the corporation will cover the cost, unless the stockholder's refusal to accept the payment was unreasonable. Sa madaling salita po, ang corporation ang karaniwang nagbabayad ng appraisal expenses. Maliban kung halos kapareho ng unang alok nila ang halaga ng appraisal, o kung hindi, makatwiran ang pagtanggi ng stockholders sa bayad. Furthermore, let us discuss the liability for costs and expenses of appraisal. The responsibility for this cost depends on the situation. First, the corporation will bear the cost if the amount it initially offered is lower than the fair value determined by appraisers. A legal case is filed and the court finds the stockholder's refusal to accept payment was justified. Second, the dissenting stockholder will bear the cost if the appraised fair value is nearly the same as the corporation initial offer. A legal case filed and the court rules that the stockholder unreasonably refused the payment. Sa madaling salita po, kung mababang alok ng corporation kumpara sa appraised value, sila ang magbabayad. Ngunit kung halos pareho ang halaga o hindi makatwiran ang pagtanggi ng stockholder, siya ang may pananagutan sa gastos. For the final section of the appraisal rights, Section 86 highlights an essential procedure for dissenting stockholders. A stockholder who exercises their appraisal right must submit their stock certificates to the corporation within 10 days for proper notation, officially marking them as dissenting shares. There are two key points to remember. First, timely submission is crucial. If the stockholder fails to submit the certificates within 10 days, the corporation has the option to terminate their appraisal rights. The second is the effect of transfer. If the dissenting shares are sold or transferred, the new owner will gain all rights of a regular stockholder, including dividends, while the original loses their appraisal rights. Sa madaling salita po, ang isang stockholder na gustong gamitin ang kanyang appraisal right ay kailangang ipasa ang kanyang stock certificates sa loob ng 10 days. Kapag hindi ito nasagawa, maaaring mawalan siya ng karapatan sa patas na kabayaran. Kung ang shares ay may lipat sa iba, ang bagong may-ari na ang makakuha ng lahat ng benepisyo bilang isang regular na stockholder. Next, let us discuss the importance of notation on the certificate of dissenting shares as stated in Section 86. Section 86 requires a dissenting stockholder to submit their stock certificates within 10 days for notation as dissenting shares. This ensures that as per Section 83, voting and dividend rights are suspended, except as provided in Section 83 and 84. For the transfer of dissenting shares, a stockholder who has demanded payment for their shares may still transfer or sell them. However, this leads to two key effects. First, the transferee becomes a regular stockholder with the right to receive all dividend distributions. Second, the transferor loses their appraisal right and will no longer be entitled to payment for the fair value of the shares. And that concludes my discussion on Title 10, Appraisal Right. I hope this has provided you with a clear understanding of its key provisions and implications. The rest of the topics will now be discussed by my group mates. Thank you for your attention. Shukran and wassalam.
Good day everyone. Today I will be discussing to you non-stock corporation. So first, the definition of non-stock corporation according to the Section 86. So for purposes of this code and subject to its provisions on dissolution, a non-stock corporation is one where part of its income is distributable as dividends to its members, trustees, or officers, provided that any profit which a non-stock corporation may obtain incidental to its operation shall, whenever necessary or proper, be used for the furtherance of the purpose or purposes for which the corporation was organized, subject to the provision of this title. So, basically, a non-stock corporation is an organization where no part of its income is distributed as dividends to its members, trustees, or officers. Instead, any profit earned from its operation must be used to further the purpose for which the corporation was established. So this means that while a non-stock corporation may generate income, it cannot distribute profits for personal gain, but must reinvest them to support its mission, such as funding programs, expanding services, or improving operations. So additionally, the provisions governing stock corporations may also apply to non-stock corporations when relevant, except in cases where specific rules under this title provide otherwise. So we need to note that the fact that a non-stock corporation earns a profit does not mean it is a profit-making corporation, as long as the profit or income is used solely for the purposes stated in its articles of incorporation and is not distributed to incorporators, members, or officers. The corporation remains classified as non-stock. So next is the purposes. So according to the Section 87, non-stock corporations may be formed or organized for charitable, religious, educational, professional, cultural, fraternal, literary, scientific, social, civic service, or similar purposes like trade industry, agricultural, and like chambers or any combination thereof, subject to the special provisions of the title governing particular classes of non-stock corporations. So a non-stock corporation can be created for purposes that serve the public good rather than for profit. So these purposes include charity, religion, education, science, culture, civic service, and other similar fields. So additionally, organizations like trade and industry chambers, agricultural groups, and professional associations can also be classified as non-stock corporations. Some corporations may combine multiple purposes as long as they follow the specific rules that apply to their category. Essentially, non-stock corporations exist to benefit a cause or a community rather than to generate income for private individuals. Next is the characteristics of non-stock corporation. So, number one, it does not have capital stock divided into shares. Number two, no part of its income during its existence is distributable as dividends to its members, trustees, or officers. 3. As a general rule, it is not empowered to engage in business with the object of making income or profits, directly or indirectly. However, it is not prohibited to make income or profits as an incident to its operation, for there is non-transferability of membership. 5. The right to vote of members may be limited, broadened, or even denied in the Articles of Incorporation or the bylaws. So, 6. Non-stock corporation may, through their Articles of Incorporation or their bylaws, designate their governing boards by any name other than as Board of Trustees. Number 7, bylaws may provide that the members may hold their meetings at any place even outside the place where the principal office of the corporation is located, provided that such place is within the Philippines. 8, a non-stock corporation is not allowed to distribute any of its assets, any incidental income or profit made by the corporation during the existence. Number 9, a non-stock corporation cannot be converted into a stock corporation by mere amendment of its articles of incorporation, because the convention would change the corporate nature from non-profit to profit. So, a non-stock corporation has several key characteristics that distinguish it from a stock corporation. So, first, it does not have capital stock divided into shares, meaning ownership is not based on stock ownership. Second, it cannot distribute its income as dividends to its members, trustees, or officers, ensuring that any earnings are used solely for the corporation's intended purpose. While it is generally not created for profit making, it is allowed to generate income as long as it is incidental to its operations. So, membership in a non-stock corporation is also non-transferable, meaning one cannot sell or pass on their membership to another person. So, the right to vote may be limited, expanded, or even denied depending on what is stated in the corporation's article of incorporation or bylaws. Additionally, the governing board does not necessarily have to be called a board of trustees, so the corporation may assign a different name through its bylaws or articles of incorporation. So, meetings of the members can be held anywhere in the Philippines, even outside the location of the corporation's principal office, as long as permitted by the bylaws. So, furthermore, a non-stock corporation cannot distribute any of its assets, including any income or profit earned during its existence, ensuring that its resources remain dedicated to its purpose. So lastly, a non-stock corporation cannot simply be converted into a stock corporation by amending its articles of incorporation. So, as this would fundamentally alter its nature from a non-profit to a profit-driven entity. So next is the right to vote in a non-stock corporation. So, according to Section 88, the right of the members of any class or classes to vote may be limited, broadened, or denied to the extent specified the articles of incorporation or the bylaws, unless so limited, broadened, or denied. Each member, regardless of class, shall be entitled to one vote, unless otherwise provided in the articles of incorporation or the bylaws. A member may vote by proxy in accordance with the provision of this code. The bylaws may likewise authorize voting through remote communication and or in absentia. So, in non-stock corporations, shareholders may generally transfer their shares. Thus, on the death of a shareholder, the executor or administrator duly appointed by the court is vested with the legal title to the stock and entitled to vote it. Until a settlement and division of the estate is affected, the stocks of the decedent are held by the administrator or executor. So, on the other hand, membership in and all rights arising from non-stock corporation are personal and non-transferable unless the articles incorporation or the bylaws of the corporation provided otherwise. In other words, the determination of whether or not that members are entitled to exercise their voting rights depends on those articles of incorporation by law. So the right to vote in a non-stock corporation depends on what is stated in the articles of incorporation or bylaws. So the corporation has the power to limit, expand, or even deny voting rights for certain members or member classes. So, however, if there are no specific limitations, each member automatically has one vote. So, members can also vote by proxy, meaning they can authorize someone else to vote on their behalf. as long as it follows the rules set by the corporation code. Additionally, the bylaws may allow voting through remote communication or in absentia, enabling members to participate in decisions even if they are not physically present. So unlike stock corporations, where ownership shares can be transferred or inherited, membership in a non-stock corporation is personal and generally non-transferable. So this means that when a member passes away, their voting rights do not automatically transfer to their heirs or estate administrators unless the articles of incorporations or bylaws specifically allow it. This is the non-transferability and termination of membership. So, according to Section 89, non-transferability of membership. So, membership in a non-stock corporation and all rights arising therefrom are personal and non-transferable unless the articles of incorporation or the bylaws otherwise provide. Next, and according to the Section 90, termination of membership, membership shall be terminated in the manner and for the causes provided in the articles of incorporation or the bylaws. Termination of membership shall extinguish all rights of a member in the corporation or in its property unless otherwise provided in the articles of incorporation or the bylaws. So, in a non-stock corporation, membership and all associated rights are considered personal and cannot be transferred to another person. So, this means that a member cannot sell, assign, or pass on their membership to someone else unless the corporation's articles of incorporation or bylaws specifically allow it. So, and in a membership in a non-stock corporation can be terminated based on the rules stated in the articles of incorporation or bylaws. So once a person's membership is terminated, they lose all their rights in the corporation, including any interest in its assets or properties, unless stated otherwise in the governing documents. This ensures that only active members who comply with the corporation's rules can exercise membership rights. So next is the requirements for termination of membership. So there are two. First is notice to the member, and second is the opportunity to be heard. So the termination of membership in a non-stock corporation must follow due process, which includes two key requirements. First is notice to the member. So the member must be formally informed about the termination proceedings, including the reasons for removal. Next is opportunity to be heard. So the member must be given a chance to explain or defend themselves before a final decision is made. So next is the election and term of trustees. According to Section 91, the number of trustees shall be fixed in the articles of incorporation or bylaws, which may or may not be more than 15. They shall hold office for not more than 3 years until their successors are elected and qualified. Trustees elected to fill vacancies occurring before the expiration of a particular terms shall hold term only for the unexpired period. So, except with respect to independent trustees of non-stock corporation vested with public interest, only a member of the corporation shall be elected as trustee unless otherwise provided in the articles of incorporation of a non-stock corporation or bylaws. The members may directly elect officers of a non-stock corporation. So, in a non-stock corporation, the number of trustees is determined by the articles of incorporation or bylaws and may exceed 15. So trustees serve a term of no more than 3 years and remain in office until the successors are elected and qualified. If a trustee vacates their position before the end of their term, a replacement is elected to serve only the remaining period. So generally, only members of the corporation can be elected as trustees, except in cases where the corporation has independent trustees due to its public interest status, unless otherwise stated in the articles of incorporation or bylaws. Members of a non-stock corporation may directly elect their officers. So, in this section, we need to note that the number of trustees shall be fixed in the articles of incorporation or bylaws, which or may not be more than 15. They shall hold office for not more than 3 years until the successors are elected and qualified. So next is the list of members and proxies, place of meeting. So according to Section 92, corporation shall at all times keep a list of its members and their proxies in the form of the commission may require. So the list shall be updated to reflect the members and proxies of record 20 days prior to any scheduled election. So the bylaws may provide that the members of a non-stock corporation may hold their regular or special meeting at any place, even outside the place where the principal office of the corporation is located, provided that the proper notice is sent to all members indicating the place, date, time, provided further that the place of meeting shall be within the Philippine territory. So, a non-stock corporation is required to maintain an updated list of its members and their proxies in the format prescribed by the Commission. So, this list must be updated at least 20 days before any scheduled election to ensure that the records are accurate. Additionally, the corporation's bylaws may allow members to hold their regular or special meeting at any location, even outside the city or province where the principal office is located. However, all members must receive proper notice indicating the date, time, and place of the meeting. While meetings can be held in different locations, they must always take place within the Philippines. Next is the distribution of assets in non-stock corporations. So, according to Section 93, the assets of a non-stock corporation undergoing the process of dissolution for reasons other than those set forth in Section 139 of this Code shall be applied and distributed as follows. A. All liabilities and obligations of the corporation shall be paid, satisfied, and discharged, or adequate provision shall be made therefore. B. Assets held by the corporation upon a condition requiring return, transfer, conveyance, and which condition occurs by reason of the dissolution shall be returned, transferred, or conveyed in accordance with such requirements. C. Assets received and held by the corporation subject to limitations permitting their use only for charitable, religious, benevolent, educational, or similar purposes, but not held upon a condition requiring return, transfer, or conveyance by reason of the dissolution, shall be transferred or conveyed to one or more corporations, societies, or organizations engaged in activities in the Philippines, substantially similar to those of the dissolving corporation according to a plan of distribution adopted pursuant to this chapter. D. Assets other than those mentioned in the preceding paragraphs, if any, shall be distributed in accordance with the provisions of the Articles of Incorporation or the bylaws to the extent that the Articles of Incorporation or the bylaws determine the distributive rights of members or any class or classes of members or provide for distribution. And E. In any other case, assets may be distributed to such persons, societies, organizations, or corporations, whether or not organized for profit, as may be specified in a plan of distribution adopted pursuant to this chapter. So, when a non-stock corporation is dissolved for reasons other than those stated in Section 139, its assets must be distributed following a specific process. So, first, payment of liability. So, before anything else, the corporation must settle all its debts and obligations or make adequate provisions to do so. Second is return of assets with conditions. So, if the corporation holds assets under a condition that requires them to be returned, transferred, or conveyed in the event of dissolution, these assets must be handled as required. Third is charitable and similar assets. So, any asset received for charitable, religious, benevolent, or educational purposes, but without conditions for return, must be transferred to one or more organizations in the Philippines that have similar purposes. Fourth is other assets. So, any remaining assets not covered by the above rules shall be distributed according to the Articles of Incorporations or bylaws. These documents may determine how assets are allocated among members or specific groups. Fifth is final distribution. So, if no specific provisions apply, the remaining assets may be distributed to individuals, organizations, or corporations, whether they are for profit or non-profit, as determined in a plan of distribution adopted by the corporation. Next is the Section 139. So, corporate liquidation. So, except for banks, which shall be covered by the applicable provisions of Republic Act 7653, otherwise known as the New Central Bank Act, as amended, and Republic Act number 3591, otherwise known as the Philippine Deposit Insurance Corporation Charter, as amended. Every corporation whose charter expires pursuant to its Articles of Incorporation is annulled by forfeiture, or whose corporate existence is terminated in any other manner shall nevertheless remain as a body corporate for 3 years after the effective date of dissolution for the purpose of prosecuting and defending suits by or against it and enabling it to settle and close its affairs, dispose of and convey its property, and distribute its assets, but not for the purpose of continuing the business for which it was established. At any time during the said 3 years, the corporation authorized and empowered to convey all of its property to trustees for the benefit of stockholders, members, creditors, and other persons in interest after any such conveyance by the corporation of its property in trust for the benefits of its stockholders, members, creditors, and others in interest. All interest which the corporation had in the property terminates, the legal interest vests in the trustees, and the beneficial interest in the stockholders, members, creditors, or other persons in interest. So, except as otherwise provided for in sections 93 and 94 of this code, upon the winding up of corporate affairs and any asset distributable to any creditor or stockholder or member who is unknown or cannot be found shall be escheated in a favor of the national government, except by decrease of capital stock and as otherwise allowed by this code. No corporation shall distribute any of its assets or property except upon lawful dissolution and after payment of all its debts and liabilities. So, when a corporation charter expires, is annulled, or its corporate existence ends in any way, it does not immediately cease to exist. Instead, it remains a corporate entity for 3 years after its dissolution. So, during this period, the corporation is allowed to prosecute or defend legal cases. The corporation can file or respond to lawsuits, and they can also settle and close its affairs, where they can finalize any outstanding matters. Third is dispose of and transfer property, so assets can be sold or distributed. Fourth is distribute remaining assets. So after settling obligations, remaining assets can be given to the stockholders for stock corporations or members for non-stock corporations. So, however, during this 3-year period, the corporation cannot continue its original business operation. So, at any time within these 3 years, the corporation may transfer all its property to trustees who will manage the assets for the benefit of stockholders, members, creditors, or other interested parties. So, once the corporation has transferred its assets to trustees, it loses all ownership rights and the trustees take over the management and distribution of the assets. So, additionally, if any assets remain untamed by creditors or members and the rightful owners are unknown or cannot be found, those assets will be escheated to the national government. So, a corporation cannot distribute its assets or property unless it is legally dissolved and has paid all its debts and liabilities, except in cases allowed by law such as reducing capital stock. So next is Section 94. So according to Section 94, a plan providing for the distribution of assets consistent with the provisions of this title may be adopted by a non-stock corporation in the process of dissolution in the following manner. A. The Board of Trustees shall by majority vote adopt a resolution recommending a plan of distribution and directing the submission thereof to a vote at a regular or special meeting of members having voting rights. B. Each member entitled to vote shall be given a written notice setting forth the proposed plan of the distribution or a summary thereof and the date, time, and place of such meeting within the time and in the manner provided in this code for the giving of notice of meetings. And C. Such plan of distribution shall be adopted upon approval of at least 2/3 of the members having voting rights present or represented by proxy at such meeting. So when a non-stock corporation is undergoing dissolution, it must create a plan for distributing its assets. So this plan ensures that all remaining assets are allocated fairly and in accordance within the law. So the process follows these steps. So first, board approval. So the Board of Trustees must first approve the plan through a majority vote and then submit it for approval by the members. Second, member notification. So all voting members must receive a written notice detailing the proposed distribution plan or summary of it. This notice must also include the date, time, and place of the meeting where the plan will be discussed. Third, member approval. So the plan will be adopted if at least 2/3 of the voting members either present at the meeting or represented by proxy approve it. So next is the differences between stock corporations and non-stock corporations. So first, capital and ownership. So stock corporations have capital stock divided into shares, meaning ownership is based on the number of shares a person owns, while non-stock corporations do not have capital stock. Instead, they have members who contribute to the corporation's goals without owning shares. Next is purpose, and profit distribution. So, stock corporation are organized for profit. So, meaning they generate the revenue and distribute profits to shareholders in the form of dividends, while non-stock corporations are not primarily organized for profit. So, any profit they earn is used to further their mission and cannot be distributed to members. Third is governance. So, stock corporations have a board of directors limited to 15 members, and each director serves for 1 year, while non-stock corporations may have more than 15 trustees, and their term can last up to 3 years. Next is elections of officers. So, stock corporations, officers are elected by the board of directors, while non-stock corporations, officers can be elected directly by members unless stated otherwise in the corporation's bylaws. Next is meetings and location. So, stock corporations, stockholders' meetings must be held in the same city or municipality where the principal office is located, while non-stock corporations, members' meetings can be held anywhere in the Philippines as long as proper notice is given. So next is transferability of shares or membership. So stock corporations, shares can be transferred with or without the corporation's consent, while non-stock corporations, membership is personal and non-transferable unless the corporation's articles of incorporation or bylaws allow it.
Good day, everyone. Today, I will provide an in-depth discussion on closed corporations as defined under Section 85 of the Revised Corporation Code of the Philippines. A closed corporation is a specialized type of business entity designed to maintain a small, controlled ownership group. Unlike publicly traded corporations, a closed corporation operates with limited shareholders, strict stock transfer restrictions, and is prohibited from public trading. Understanding the nature and structure of a closed corporation is crucial, especially for those considering forming or investing in such a business entity. A closed corporation is defined as a corporation that explicitly includes the following provision in its articles of incorporation. First, we have the limited number of stockholders. A closed corporation must have no more than 20 stockholders. This means that only a selected group of individuals or entities can hold shares, making it a closely knit business structure. The stockholders are often family members, close friends, or business associates who prefer a controlled corporate environment. Number two, the restrictions on stock transfers. All issued stocks must be subject to specific restrictions on transfer. This means that stockholders cannot freely sell or transfer their shares without complying with the rules set in the Articles of Incorporation or internal agreements. These restrictions help maintain the original ownership structure and prevent unwanted external parties from acquiring shares. Number three, prohibition from public trading. A closed corporation cannot list its stocks on any stock exchange or offer them to the public. This limitation ensures that ownership remains within a private group and prevents external investors from influencing corporate decisions. Exceptions are even if a corporation meets all these conditions, which are limited number of stockholders, restriction on stocks transfers, prohibition from public trading, it will not be considered a closed corporation if at least two-thirds of its voting stock or voting rights are owned or controlled by another corporation that does not qualify as a closed corporation. This exception prevents large corporations from manipulating the structure of a closed corporation for regulatory advantages. So, closed corporations are governed primarily by the provisions under Title 12 for the closed corporations of the Revised Corporation Code. However, if there are legal issues that are not explicitly addressed under this title, the general provisions of the Corporation Code will apply suppletorily, meaning they will serve as a supplementary rules unless overridden by the specific provisions for closed corporations. This ensures that closed corporations function within the broader legal framework of corporate governance while maintaining their unique characteristics. Who can and cannot form a closed corporation? While most private businesses can opt to be a closed corporation, there are certain industries and business types that are prohibited from adopting this structure. This includes first, mining or oil companies, stock exchanges, banks, insurance companies, public utilities, educational institutions, and corporations declared to be vested with public interest. So first, we have the mining and oil companies. Due to the nature of their operations and required transparency, this business must remain publicly accountable. Stock exchanges. Since stock exchanges facilitate public trading, they cannot operate under closed corporation status. Banks. Banks require a high level of public confidence and regulatory oversight, making them unsuitable for the closed corporation model. Next is the insurance companies. Given the financial risks involved, these businesses must comply with strict regulations and public disclosures. Public utilities. Companies providing essential services such as electricity, water, telecommunications must remain accessible to regulatory oversight and public investment. Next is educational institutions. Schools and universities are typically regulated by government agencies and must comply with public interest laws. Last one is corporations declared as vested with public interest. These are businesses identified by law as requiring public scrutiny, often due to their impact on consumers and the economy. So these exclusions of these entities from being those closed corporation is due to the necessity of transparency, regulatory oversight, and public accessibility in their operations. So let's proceed to the characteristics of a closed corporation. First, First characteristic is all about the stockholders manage the corporation instead of the board of directors. Unlike regular corporations, where a board of directors is responsible for decision making and management, a closed corporation can authorize its stockholders to manage the business directly as specified in its articles of incorporation. When stockholders take on this role, they assume the same responsibilities and liabilities as directors under the corporation code. This also means that stockholders may be personally liable for corporate torts or the wrongful acts committed by the corporation, unless the corporation obtains adequate liability insurance to protect them. Second characteristic is quorum may be greater than a mere majority. So in regular corporations, a quorum or the minimum number of members needed to make decisions is usually a majority of stockholders or directors. However, in a closed corporation, the articles of incorporation or bylaws may require a higher percentage for certain decisions, ensuring that significant corporate actions require broader approval. Number three is the restrictions on transfer of shares can be validly imposed. One of the main features of a closed corporation is the limitation on the transfer of shares. Stockholders cannot freely sell or transfer their shares to outsiders unless they comply with the restrictions stated in the Articles of Incorporation, bylaws, or stockholder agreements. These restrictions help maintain control within a small group of stockholders and prevent unwanted third parties from acquiring shares. Number four, any action by the directors of a closed corporation without a meeting shall nevertheless be deemed valid. So, directors' action without a formal meeting can still be valid. In a regular corporation, board decisions usually require a formal meeting with a quorum to be valid. In a closed corporation, decisions made by the directors without holding a formal meeting may still be considered valid if agreed upon all directors. This flexibility allows closed corporations to make faster and more efficient business decisions. Number five, preemptive right extends to all stock issuances. So the preemptive right allows existing stockholders to purchase new shares before they are offered to outside investors. In a closed corporation, this right applies to all stock issuances, meaning the current stockholders always have the first opportunity to maintain their percentage of ownership. This prevents outside parties from gaining control of the corporation unless the existing stockholders choose not to exercise their preemptive rights. Number 6, deadlock in the board is settled by the SEC upon the written petition by any stockholder. So deadlocks in a board in the board are settled by the SEC. So SEC or the Security of Exchange Commission. So in cases where there is deadlock, examples are the stockholders or directors cannot agree on a crucial business decision, any stockholder can file a written petition with the Securities and Exchange Commission. The SEC has the authority to resolve the deadlock by taking actions such as appointing a provisional director, ordering the dissolution of the corporation as a last resort, and implementing other measures to break the deadlock. So the last characteristics is a stockholder may withdraw and avail of his right of appraisal. So stockholders may withdraw and exercise the right of appraisal. If a stockholder disagrees with major corporate decisions, they have the right to withdraw from the corporation and demand that the company buy back their shares at a fair value. The right applies in situations such as major changes in corporate structure or the mergers, consolidation, or amendments to the articles of incorporation that significantly affect stockholders' rights, disagreements, and management decisions that significantly impact stockholders' interest. So let's proceed to Section 96, Articles of Incorporation. Section 96 of the Revised Corporation Code of the Philippines outlines the specific provisions that the closed corporation's articles of incorporation may include. These provisions allow the corporation to operate with more flexibility than regular corporations. So number one, a closed corporation's article of incorporation may include the following special provisions. First provisions is the classification of shares and transfer restrictions. The corporation may classify its shares into different types or classes with varying rights and privileges. It can set qualifications for stock ownership, meaning that only certain individuals or groups can hold shares. It may also impose restrictions on the transfer of shares. For example, shares may require approval from existing stockholders before being transferred to another party. Next provision is provision letter B is classification of directors. The corporation can divide its board of directors into different classes, where each class of shares elects a specific group of directors. This structure ensures that certain stockholders retain control over board decisions. For example, Class A shares could have the right to elect three directors, while Class B shares elect two directors. So letter C, greater quorum or voting requirements. The corporation may establish higher quorum or voting requirements than what is provided under law. This means that for board or stockholder decisions, a larger percentage of votes may be required to approve major corporate actions. This provision is useful in ensuring that significant decisions are not made without the approval of substantial majority of stockholders. So, the articles of incorporation of a closed corporation may provide that the business of the corporation shall be managed by the stockholders of the corporation rather than by a board of directors. So, stockholders may directly manage the corporation instead of a board of directors, unlike regular corporations, where a board of directors is required to manage the business. A closed corporation may allow stockholders to manage the corporation directly. There's no need to call stockholder meetings to elect directors since the stockholders themselves will automatically act as directors. The stockholders will be considered as the board of directors for purposes of corporate governance. The stockholders will also be subject to all liabilities and responsibilities that apply to corporate directors under the law. So, appointment of officers and employees by stockholders in a regular corporation The board of directors elects or appoints corporate officers, example, the president, treasurer, or secretary, and may also appoint key employees. However, in a closed corporation, the articles of incorporation may allow the stockholders instead of the board to elect or appoint. Example of this are the all corporate officers, employees, only certain specified officers. So this provision provides greater control to stockholders over key management decisions, ensuring that only trusted individuals are appointed to run the business. Let's proceed to the articles of incorporation of a closed corporation. A closed corporation operates differently from a regular corporation, and its articles of incorporation may include special provisions. So, first provision we have the classification of shares, ownership qualifications, and transfer restrictions. A closed corporation may create different classes of shares, each with unique rights and privileges. The articles of incorporation may also set qualifications for who can own or hold shares. Restrictions on share transfers prevent stockholders from selling their shares to outsiders without approval. So this provision ensures that ownership remains within a selected group and prevents outsiders from gaining control over the business. Next is the classification of directors based on share classes. So the articles of incorporation may divide directors into different classes, and each class may be elected only by a specific group of stockholders. This structure ensures that certain stockholders retain exclusive voting rights over specific board positions. This provision protects minority stockholders by allowing them to elect their own representatives to the board. Number three is the greater quorum or voting requirements in meetings. The articles of incorporation may require a higher percentage of stockholders or directors to be present for meeting to be valid. It may also require a higher vote percentage for approving a major decisions. This provision ensures that important decisions cannot be made by a small group without board approval. So, number four, management by stockholders instead of a board of directors. Unlike regular corporations where a board of directors manages the business, a closed corporation may allow stockholders to run the business directly. In such cases, no separate board of directors is required. The stockholders themselves act as the board. Stockholders who manage the corporation will assume the legal responsibilities and liabilities of directors. This provision gives stockholders direct control over business operations, making decision making faster and more flexible. Let's proceed to Section 97 Validity of Restrictions on Transfer of Shares. So, Section 97 states that restriction on the transfer of shares in a closed corporation are only valid if they are explicitly stated in the Articles of Incorporation, bylaws, and stock certificate. If these restrictions are missing from any of these documents, they cannot be enforced against a buyer who purchases shares in good faith. The law ensures that transfer restrictions must be reasonable and cannot completely prevent a stockholder from selling their shares. The most common restriction is the right of first refusal, where existing stockholders or the corporation get the first chance to buy the shares under fair terms and within a specified period. If no one buys the shares within the given time, the stockholder is free to sell to any third party. This balances the corporation's control over ownership while ensuring stockholders have a way to exit the company. Let's proceed to the conditions for the validity of restriction on the right to transfer shares. So, in a closed corporation, stockholders cannot freely transfer or sell their shares to outsiders unless they comply with certain conditions. These conditions ensure that ownership remains within the existing stockholders while also giving individual stockholders a way to exit the corporation if needed. So, first condition, they must appear in the articles of incorporation and in the bylaws as well as in the certificate of stock. So, for restrictions on the transfer of shares to be legally binding, they must meet two conditions. They must be explicitly stated in three key documents: articles of incorporation, bylaws, and stock certificate. If the restriction does not appear in all three, it cannot be enforced against a buyer in good faith. Second condition, the restriction must be reasonable and should not completely block a stockholder from selling their shares. The most common restriction is the right of first refusal, which allows the corporation or existing stockholders to buy the shares first before they are sold to an outsider. So, what is the right of first refusal? If a stockholder wants to sell shares, they must first offer them to either the corporation or the existing stockholders. The offer is usually under the same terms and conditions as the intended sale to a third party. This only applies to shares that have already been issued to stockholders. So, option period for exercising the right of first refusal. The articles of incorporation, bylaws, and stock certificate must state a specific time period within which the corporation or stockholders must decide whether to buy the shares. If they fail to purchase within the stated period, the selling stockholder is free to sell to an outsider. So, the right of first refusal is a protection mechanism in closed corporations that allows stockholders or the corporation to maintain control over ownership. However, it also ensures that the stockholder is not unfairly restricted from selling their shares if no one within the corporation wishes to buy them. Let's proceed to Section 98, Effects of Issuance or Transfer of Stock in Breach of Qualifying Conditions. So, Section 98 of the Revised Corporation Code of the Philippines protects the integrity of a closed corporation by ensuring that stock transfers comply with the corporation's qualifying conditions as stated in its articles of incorporation and stock certificates. If shares are issued or transferred in violation of these conditions, the law presumes that the transferee had notice of the violation and allows the corporation to refuse the transfer. So, first provision, letter A, transferred to an ineligible stockholder. If the articles of incorporation specify that only certain qualified persons can own shares and a stock is issued or transferred to an ineligible person, the transferee is presumed to have known they were not qualified. This presumption applies if the stock certificate clearly states the qualification requirements. Example, if a corporation only allows stockholders who are doctors but shares are transferred to an engineer, the engineer is presumed to have known they were not qualified. Next provision, letter B, transfer exceeding the maximum number of stockholders. A closed corporation cannot have more than 20 stockholders. If a transfer causes the number of stockholders to exceed this limit, the transferee is presumed to have known that the transfer violates the corporation's rules. This presumption applies if the stock certificate clearly states the 20 stockholder limit. Example, if a corporation already has 20 stockholders and a new stockholder is added, they cannot claim ignorance because the stock certificate states the 20 stockholder limit. So, letter C, the violation of stock transfer restrictions. If the stock certificate clearly states that shares cannot be transferred freely and a stockholder sells to an outsider without following the rules, the buyer is presumed to have known the transfer was invalid. Example, if a stockholder directly sells shares to an outsider without offering them first to existing stockholders, the new buyer cannot claim ignorance of the restriction. Letter D, corporation's right to refuse transfer registration. So if a transfer violates any of the conditions above, the corporation has the right to refuse to register the transferee as a new stockholder. This ensures that the closed corporation maintains control over who can own its shares and prevents unauthorized stockholders from gaining rights. So example of this is if a corporation has rules limiting ownership to family members and the stockholders sell shares to an outsider, the corporation can refuse to register the transfer, preventing the outsider from becoming a stockholder. So to continue, letter E talks about when a transfer is allowed despite violations. Normally, a closed corporation can refuse to register a transfer if it violates first, letter A, ownership qualifications, letter B, the 20 stockholder limit, or letter C, stock transfer restrictions. However, there are two exceptions where the transfer will still be valid. First, if all stockholders consent. Even if the transfer violates the restrictions, it will still be allowed if all stockholders anonymously agree to accept the new stockholder. Second, if the articles of incorporation are amended, the corporation can modify its rules to allow the transfer, making it valid. So, letter F, definition of transfer. The term transfer is not limited to sales where money is involved. It also includes donations, inheritance, or any other way that ownership is passed to another person. Example, if a stockholder gives shares as a gift to a friend, it is still considered a transfer and must follow the same restrictions. So letter G, rights of the transferee or buyer of shares. So even if a transfer is invalid, the buyer, transferee, still has legal rights to cancel the transaction, rescind the transfer, or if they were misled, or claim the shares if there was a breach of warranty. Example of this is if a stockholder sells shares to a buyer without disclosing that the transfer is restricted, the buyer can sue the seller for misrepresentation. Let's proceed to Section 99, Agreements by Stockholders. So, Section 99 of the Revised Corporation Code of the Philippines clarifies the legal validity and effects of agreements among stockholders of a closed corporation. Since a closed corporation operates with fewer stockholders and often without a board of directors, stockholder agreements play a crucial role in governing corporate affairs, voting rights, management responsibilities, and financial liabilities. So, first, letter A. This talks about pre-incorporation agreements remain valid. So, any agreement signed by all stockholders before the corporation was formed will remain valid after incorporation, as long as it does not contradict the corporation's articles of incorporation. The agreement is valid regardless of where it is written, except for agreements that the law requires to be in the Articles of Incorporation. Example, before registering a closed corporation, four business partners agree that they will only sell shares to family members. Even after incorporation, this agreement remains valid, provided it does not contradict the corporation's article of incorporation. Letter B, stockholder agreements on voting rights. So this talks about stockholders can sign a written agreement that specifies how their shares should be voted during corporate decisions. This can include voting as a block, example, all stockholders agree to vote the same way, or following a specific process, example of that is consulting each other before voting. So these provisions allow greater control and unity among stockholders in decision making. So, example is three major stockholders owning 80% of shares agree to always vote together when electing corporate officers. This agreement is legally valid. So, letter C, stockholder agreements do not create partnership. So, this talks about even if stockholders enter into agreements that make them more involved in running the business, similar to how partners operate in a partnership, the law does not automatically consider them partners. This provision prevents legal disputes where a stockholder might argue that the corporation should be treated as a partnership instead. Example, if all stockholders agree to directly manage the corporation's day-to-day operations, they are still legally considered stockholders, not partners. So letter D talks about agreements that limit the powers of the board are allowed. So, stockholders can agree to limit or control the powers of the board of directors. However, stockholders who sign such agreements must take on the same liabilities as directors under the law. For example, instead of having a traditional board of directors, stockholders agree that only stockholders can approve major business decisions. Because of this, stockholders now have the same legal responsibilities as directors, including personal liability for corporate actions. So, letter E, stockholders have fiduciary fiduciary duties and personal liability. So this is all about stockholders who are actively involved in running the business must act in a good faith and in the best interest of each other and the corporation. If the corporation commits a corporate tort, or like fraud, negligence, or misconduct, stockholders can be held personally liable unless the corporation has adequate liability insurance to cover damages. Example is if stockholders personally manage the corporation and one of them commits fraud against a customer, all managing stockholders can be sued personally unless the corporation has liability insurance to cover the damages. Let's proceed to section 100 when a board meeting is unnecessary or improperly held. So, in a closed corporation, stockholders often directly manage the business, reducing the need for formal board meetings. Section 100 states that even if a board meeting was not properly called or notified, the decisions made can still be valid under certain conditions. So, even if a board meeting was not properly conducted, the actions taken are still valid if any of the following apply. So, letter A, all directors give written consent. So, letter A talks about if all directors sign a written consent before or after the action, it is considered valid. This allows flexibility in decision making without requiring formal meetings. Example, if the directors decide to approve a new business contract but did not hold a formal meeting, the decision is valid if all directors later sign a written approval. So letter B, um, all stockholders know about the action and do not object. So this is all about if all stockholders are aware of the decision and do not submit a written objection, the action is considered valid. This includes both actual knowledge, they were informed, and implied knowledge, they should have known. For example, a corporation buys new equipment without a formal meeting. If all stockholders are aware and no one objects in writing, the purchase is valid. So letter C, directors have a custom of making decisions informally. So, if directors usually make decisions informally without formal meetings and all stockholders accept this practice, their actions are still valid. This recognize that closed corporations often operate informally. Example, if the directors always approve financial transactions via email or phone calls and stockholders accept this method, such decisions are still valid. Letter D, all directors know about the decision and do not object. So, it talks about if all directors are aware of a decision and no one objects in writing, the action is valid. The objection or filed with must be prompt or it is filed immediately. So example of this is if the board hires a new manager without a formal meeting and none of the directors objects in writing, the hiring is valid. So effect of non-attendance at an improper meeting. If a director did not attend a meeting that was not properly called, their absence does not automatically invalidate the decision. However, if the director later learns about the decision and does not file a written objection with the corporate secretary, they are considered to have accepted it. Example, if a director misses a meeting where a major investment decision was made, they must file a written objection immediately if they disagree. Otherwise, the decision is considered approved. So, exceptions. The bylaws provide otherwise. If the corporation's bylaws require a formal meeting for decisions to be valid, then these rules do not apply. This means bylaws can override this section and require strict procedures. Example of this is if the bylaws state that all major financial decisions must be made in a formal meeting, then an informal decision is not valid, even if no one objects. Let's proceed to Section 101, Preemptive Right in Closed Corporations. So this section talks about a preemptive right is the right of an existing stockholder to purchase newly issued shares before they are offered to outsiders. So in closed corporations, this right applies to all stock issuances, including treasury shares or the previously issued shares that the corporation has bought back. So this applies regardless of whether shares are issued in exchange for money, property, personal services, or corporate debt payments. However, this right can be removed or modified if the articles of incorporation state otherwise. So example of this section is if a closed corporation plans to issue new shares to raise funds, the current stockholders have the first right to buy those shares before they are sold to outsiders. So let's proceed to section 102, the amendment of articles of incorporation. So section 2 talks about the articles of incorporation is the document that establishes a corporation. In a closed corporation, amending this document, especially if it involves changes to provisions required under this title, requires a high level of stockholders' approval. So any amendment removing or altering required provisions, such as restrictions on stock transfer, management by stockholders, or stockholders' limitations, must be approved by at least two-thirds of the outstanding capital stock. This includes both voting and non-voting shares. So, exception, even if the articles of incorporation specify a higher approval requirement, then the greater proportion of votes is needed to approve the amendment. Example: a closed corporation wants to remove a restriction on stock transfer from its articles of incorporation. Normally, this requires two-thirds of all outstanding stockholder votes. However, if the articles of incorporation require 75% approval, then a stricter rule applies. So let's proceed to section 103, deadlocks. So first, what is deadlock? A deadlock happens when the directors or stockholders of a closed corporation cannot reach the required number of votes to make decisions regarding the management and business affairs of the corporation. This inability to act can harm the corporation and its stockholders. So what is the role of the Securities and Exchange Commission? If a deadlock occurs and prevents the corporation from operating effectively, any stockholder can file a written petition with the Securities and Exchange Commission to resolve the dispute. The SEC has the power to arbitrate and issue various orders to break the deadlock. So, what are the actions the SEC may take to resolve a deadlock? First, amend or cancel corporate provisions. The SEC can change or remove provisions in the articles of incorporation, bylaws, or stockholders' agreements if they contribute to the deadlock. Next, cancel or modify corporate decisions. If a resolution or corporate action is causing the deadlock, the SEC can cancel, modify, or prevent its enforcement. Next, direct or prohibit specific actions. The SEC can instruct or prevent the corporation, board of directors, stockholders, or officers from taking certain actions. Next, require stock purchases. So the SEC may order the purchase of the shares of a stockholder involved in a deadlock, either by the corporation itself or other stockholders willing to buy the shares. Next is to appoint a provisional director. The SEC can assign a neutral person as a temporary director to help break the deadlock. Next is to dissolve the corporation. If the deadlock is severe and no solution is possible, the SEC may order the dissolution of the corporation. And lastly, other necessary relief. So the SEC has the power to take any other action needed to resolve the deadlock and protect the interest of the stockholders. So appointment of a provisional director. So, a provisional director is an impartial person assigned by the SEC to temporarily act as a director in the corporation. Their purpose is to help resolve the deadlock and ensure corporate operations continue. So, what are the qualifications of a provisional director? First, must be neutral, cannot be a stakeholder or creditor of the corporation or any of its subsidiaries or affiliates. Next is to has the same rights as a regular director, can attend and vote in board meetings. Lastly, not a receiver. A provisional director is not considered a receiver or custodian, meaning they do not take full control of the corporation. So, compensation of a provisional director. Their salary is agreed upon by both the corporation and the provisional director. If no agreement is reached, the SEC can determine the compensation. So, deadlock in closed corporation. If the directors or stockholders are so divided respecting the management of the corporation's business and affairs that the votes required for any corporate action cannot be obtained, with the consequence that the business and affairs of the corporation can no longer be conducted to the advantage of the stockholders generally. So the remedy in case of deadlock, the Securities and Exchange Commission, upon written petition by any stockholder, shall have the power to arbitrate the dispute. Note, the power given to the SEC by the above provision may be exercised notwithstanding any contrary provision in the Articles of Incorporation or bylaws or agreement of stockholders of a closed corporation. So, as I've said on the other slide, on the previous slide, provisional director, an impartial person who is neither a stockholder nor a creditor of the corporation or of any subsidiary or affiliate of the corporation, and whose further qualifications, if any, may be determined by the SEC. Let's proceed to Section 104, Withdrawal of Stockholder or Dissolution of Corporation. So, Section 104 of the Revised Corporation Code provides stockholders of a closed corporation with two significant rights. First, the right to withdraw from the corporation by selling their shares to the corporation. Second, the right to petition for the corporation's dissolution under certain circumstances. So first, a stockholder may compel the corporation to purchase their shares at fair value, which must not be lower than the par or issued value of the shares. However, this can only be done if the corporation has sufficient assets to cover its debts and liabilities, excluding its capital stock. This provision ensures that stockholders who no longer want to be part of the corporation have a guaranteed way to liquidate their shares, provided that the financial health of the company allows it. Second, a stockholder may petition the Securities and Exchange Commission to dissolve the corporation when its directors, officers, or controlling stockholders engage in actions that are illegal, fraudulent, dishonest, oppressive, or unfairly prejudicial to either the corporation or any of its stockholders. Additionally, if corporate assets are being misapplied or wasted, a stockholder may also request dissolution. This serves as a legal safeguard to protect minority stockholders from abuse or mismanagement within the corporation. So, what are the remedies available to stockholder? First, right to withdraw and sell shares to the corporation. A stockholder can force the corporation to buy their shares at fair value, not less than the par or issue value. The corporation must have enough asset to cover its debts and liabilities, excluding capital stock. This protects stockholders from being trapped in a corporation without a way to exit. Second is right to petition for corporate dissolution. A stockholder may request the SEC to dissolve the corporation if the corporation's directors, officers, or controlling stockholders engage in illegal, fraudulent, dishonest, oppressive, or unfairly prejudicial acts against the corporation or any stockholder. Second, the corporate assets are being misapplied or wasted, which can harm the corporation's financial stability. So these remedies ensure that stockholders in a closed corporation are protected from being forced to stay in unfavorable business environment and have legal options when mismanagement occurs. So stock corporation versus closed corporation. Under stock corporation, its articles of incorporation need only contain the general matters enumerated in Section 13 of the Revised Corporation Code. Meanwhile, the closed corporation, its articles of incorporation must contain the provisions required by Section 96 as well as the general matters enumerated in Section 13 of the Revised Corporation Code. Next, under stock corporation, the business of the corporation is managed by the board of directors. However, in closed corporation, the business of the corporation is managed by the board of directors. However, it may be managed by the stockholders if the articles of incorporation so provide, but they are liable as directors. Next, under stock corporation, the corporate officers are elected by a majority vote of all the members of the board of directors. In closed corporation, the corporate officers may be elected or appointed by the stockholders if provided in its articles of incorporation. Next, stock corporation. Under stock corporation, arbitration in case of deadlock by the SEC is not a remedy in case the directors are so divided respecting the management of the corporation. Under closed corporation, arbitration in case of deadlock by the SEC is a remedy in case the directors are so divided respecting the management of the corporation. Lastly, under stock corporation, the purchase by the corporation of its own stock must always be made from the unrestricted retained earnings except as regards redeemable shares. Under closed corporation, the corporation may be ordered by the SEC in case of deadlock to purchase its own shares from the stockholders regardless of the availability of unrestricted retained earnings.
Good day everyone. I will be discussing the specific corporation. So a specific corporation is a type of corporation that acts in a specific regulation which is different from a non-stock or regular stock or non-stock corporation. So under the Revised Corporation Code of the Philippines, there are three types of specific corporation. It can be the educational corporation, the one-person corporation, and the religious corporation. So for this discussion, we're going to discuss each type of special corporation. The first type of specific corporation is yung educational corporation. So ang educational corporation, obviously it is for educational purposes. And it can be a stock or a non-stock. Ang non-stock, yun na yung for non-profit, and ang stock corporation, yun na yung for profit. So, under the Section 106, kinakailangan na yung educational institution is magsunod sa regulations or governance na nilagay sa Revised Corporation Code. Unang-una, as for the composition, kinakailangan na a corporation or educational corporation will have or must have at least 5 but not more than 15 na trustees. As for the term sa office, kinakailangan mag-serve ang isang trustee for a fixed term of 5 years unless may ibang sinabi na term sa Articles of Corporation. As for the rotation system naman, instead na palitan lahat ng trustees at once, 1/5 lang yung must step down each year. Nagpapalitan naman sila nung bago. As for the vacancy, halimbawa may trustee na nag-resign or nag-resign siya bago pa matapos yung termino niya, pwede siyang palitan ng bago using an election method. Pero, yung papalit sa kanya is kinakailangan lang is mag-serve siya doon sa natira na term nung umalis na trustee. And lastly, for the majority rule, kinakailangan na majority ng nandoon na trustee is of course Filipino citizen. The second type of specific corporation is yung religious corporation, wherein ang religious corporation, it is a non-profit corporation for religious purposes. And ang responsibility niya is to manage church properties, religious activities, and spiritual missions while following the special legal provisions na gi-provide ng revised corporation code. And may two types ang religious corporation. It can be the corporation soul and the religious societies. Ang corporation soul, ito na yung from the word soul, isa lang yung nagmamanage dito. And it's formed by one single religious leader, which can be a bishop, a priest, or a minister. And ang purpose niya is to manage the properties ng church on behalf of the organization. And yung church leader, siya yung nag-a-act as a legal representative sa lahat ng civil matter under the church organization. And the second one is the religious societies, wherein ang pinagkaiba nito sa nauna is that two or more individuals ang nagmamanage dito for religious missions, spiritual activities, or community-based religious functions. And then dito, it acts like an organization compared sa nauna, wherein isa lang yung nag-act on behalf of the organization. Dito, lahat-lahat nagtutulungan in order to achieve lahat ng missions ng organization nila. In order to become a corporation soul, the chief archbishop, bishop, priest, minister, rabbi, or presiding elder of any religious denomination must file with the SEC the Articles of Incorporation. So, ito yung mga contents under the Article of Incorporation. Unang-una is yung name and purpose. Kinakailangan mapakita kung ano yung name ng organization and ano yung purpose nila or mission nila for religious ba, for educational, or for charitable purposes. Pangalawa is yung principal office, yung legal address nila. And pangatlo, the leadership and succession. Dito, dinedefine kung sino ba yung mag-lead sa corporation nila and kung sino yung mag-a-appoint and kung paano sila mag-a-appoint. And also, the powers and responsibilities. Ito na yung different responsibilities ng corporation's authority over the ownership ng property, financial management, or for governance. And lastly, for dissolution, kung halimbawa ititigil na nila yung organization nila, paano ba nila hahatiin lahat ng asset and ano yung process kung paano nila isasara yung organization nila. A religious corporation can own, acquire, or dispose of property. Pero may mga restrictions kasi kinakailangan na ma-ensure na nagamit yung property ng maayos and in case na mismanage yung property. So, meron dito tatlong types kung paano yung process. Unang-una is yung acquisition of property. Sa acquisition of property, yung corporation soul, may karapatan siyang bumili or mag-receive ng donation galing sa iba. Pero yung na-receive niya na property, kinakailangang magamit niya only for religious-related activities. Hindi niya pwedeng gamitin yun for personal benefits. Pangalawa is yung alienation of property or the sale or transfer. As for the alienation, ito na yung selling, transferring, mortgaging, or donating church property. Dito, bago siya mangyari, kinakailangan na i-approve muna ng head ng organization nila. And yung sale or transfer, kinakailangan related din for religious activities. And lastly, the legal restrictions and the court intervention. So, dito, kapag na-misuse yung church property, dito na papasok yung korte, mag-intervene sila, and sila yung magde-decide kung ano mangyayari in case of any conflict in the church properties. So, as for the dissolution and the succession of religious corporation, may sinusunod din silang mga rules and regulations. So, una-una, as for the dissolutions is that ibang dissolution, ito yung closing of religious corporation. So, may dalawang legal ways or legal reasons kung bakit nagdi-dissolve yung isang corporation. Una-una, it is either voluntarily, and ang pangalawa is legal requirement yun. Unang-una, for voluntary reasons, halimbawa yung religious leader, nag-decide siya na isarado na yung corporation kasi nga hindi na relevant yung purpose nung church organization nila. And pangalawa is it is legally required. Halimbawa, nag-violate sila sa rules or law, na mismanage yung asset, kaya na bankrupt, or nawala yung religious purpose ng corporation nila. So, sabi dito, the SEC or the Securities and Exchange Commission, sila yung nag-oversee ng process to ensure na nag-follow sila sa lahat ng legal requirements. And as for the asset contribution, nakabase ito dun sa religious law given nung nag-start pa lang silang gawin yung organization or corporation. And as for the filing of vacancies for the succession of religious leader, kinakailangan na kapag namatay, umalis, or nag-assign yung isang corporation sole leader, kinakailangan na may proper succession process. And yung papalit, kinakailangan niya mag-submit ng official documents sa SEC, get approval from religious authorities, and legally assume control sa whole organization in order to ensure a smooth process in the succession. So finally, the last type of special corporation is the one-person corporation. So from the word one person, ito yung nag-iisang stockholder lang and siya nagmamanage, yung director and president ng whole organization. So compared sa sole proprietorship, which is an accounting term, ang one-person corporation is may legal limited liability protection, wherein ang ibig sabihin nito is that yung owner's personal asset is hindi at risk in case na magkaroon ng utang yung business or magkaroon ng legal issues. So, may 4 na features ang OPC. Una is there's no minimum capital stock required, meaning mas mapapadali yun sa mga small business na mag-register under the OPC without a large initial investment. And pangalawa, nominee and alternate nominee requirement. In case na mamatay or magkaroon ng incapacity sa sole stockholder, kailangan niya mag-appoint ng nominee or alternate nominee kung hindi available yung naunang gi-appoint nung sole stockholder. And pangatlo, compliance with the SEC requirements. Kinakailangan na mag-submit ng annual financial statements sa SEC and maintain the corporate financial records. And lastly, sino yung dapat mag-register under the OPC? It should be the entrepreneurs, the professional, and the small business owner na nag-register under the OPC. So, as for the articles of incorporation of the OPC and the nominee and the alternate nominee, there are different types of rules and regulation. So, una-una, for the articles of incorporation under the OPC is actually may pagka-similar lang siya dun sa religious corporation, wherein kinakailangan ng name, nationality, residence, the nominee and alternate nominee, business purpose, corporate term, the capital stock, the legal address, and the declaration of compliance. Ang declaration of compliance, ito na yung parang statement na pinapakita ng company na nag-follow sila sa legal rules and regulations ng Revised Corporation Code. And next, for the roles ng nominee and the alternate nominee, ang nominee, ito yung temporarily pumapalit doon sa sole stockholder in case na namatay or incapacitated siya. And ang alternate nominee, ito naman yung papalit kapag hindi na available yung naunang nominee. Remember na yung nominee, temporary lang siya. Kapag may pumalit na legal person na dapat pumalit, sila dapat yung pagmamanage ng organization and pwede na mag-step down yung nominee. And this designation must be put in writing and kinakailangan yun masubmit sa SEC. So the next slide is about the treasurer, corporate secretary, and other officers, and the minute books, records, and reportorial requirements. So as for the treasurer, yung stockholder, pwede siyang mag-act as treasurer itself and pwede siyang mag-manage ng own financial regulations and responsibilities directly. But as for the corporate secretary, kailangan niya mag-hire ng Filipino citizen because he cannot act as a secretary himself. And as for the other officers, pwede siya mag-hire ng mga managers, accountants, and other executives to handle the daily operations ng business. And as for the minute books, records, and repertorial requirements, so like other corporation, kinakailangan din mag-maintain o mag-submit ng proper records ang one-person corporation. Unang-una, for the minute books and corporate records, kinakailangan niya ma-record lahat ng decisions and resolutions in the minutes book. And as for the annual financial statement, every year, an OPC must submit a financial statement. And if yung total liabilities niya is mag-exceed ng 600,000, kailangan yun is the AFS or the financial statement must be audited by a certified public accountant. And lastly, for the SEC reporting requirements, kinakailangan nitong mag-disclose ng transactions as for related to self-dealings or related transactions. For self-dealings, yun yung mga own benefits, and for related transactions involving stockholders of the family or any affiliated companies na related sa OPC.
Now let's proceed to Article 14 that discusses about dissolution. So let's discuss the different sections that belongs to Title 14 dissolution. So the first section is Section 133, the methods of dissolution. So a corporation can be dissolved in two ways, and these are voluntary and involuntary. For voluntary, this is the dissolution or the decision made by the corporation, and for involuntary, a dissolution forced by law or the government. So under voluntary dissolution, these are the ways a corporation can decide to end its business. First is by board and stockholder or member approval if there are no creditors that are affected. So the corporation can dissolve if the board of trustees or directors and the stockholders and members agree and there are no unpaid debts that will be affected. Second is by the Security and Exchange Commission judgment if the creditors are affected. So if a corporation has debts, it cannot dissolve on its own. It must get approval from the Security and Exchange Commission, which will ensure that the creditors are paid before the company closes. Third is by amending the articles of incorporation to shorten the corporate term. So the corporation can change its articles of incorporation to set an earlier expiration date, causing it to dissolve naturally on that date. Fourth is by verified declaration for corporate soul. So a corporate soul, let's just say religious organization like churches, can dissolve by submitting a verified declaration to the Security and Exchange Commission. And lastly is through merger or consolidation. So if a corporation merges with another or becomes a part of a new corporation, it automatically dissolves. So as an example is two competing cell phone companies merge into one, and under original corporation that is already dissolved or ceased to. Second method of dissolution is the involuntary dissolution. So these are the ways a corporation can be forced to close by law or the government. First is by expiration of corporate term. So if a corporation was only approved for a certain period, like let's just say for 10 years, it will automatically dissolve when that time is up. Second is by legislative enactment. So the government, like the Congress, can pass a law dissolving a corporation, and it is usually for public interest. Third is by court order. A court can order the dissolution of a corporation, and it is usually due to illegal activities. Fourth is failure to organize and commence business within 5 years. So if a company does not start its operation within 5 years after incorporation, the Security and Exchange Commission can dissolve it. Fifth is inactivity for 5 consecutive years, leading to delinquent status. If the corporation or the operation of the corporation do not resume within 5 years, the Security and Exchange Commission revokes the certificate of incorporation. So if a corporation stops operating for 5 years and does nothing to revive itself within the next 2 years, the Security and Exchange Commission will permanently revoke its registration. And lastly is by Security and Exchange Commission order due to violations of existing laws. So if a corporation breaks serious laws, the Security and Exchange Commission can dissolve. Next section under Title 14 is Section 134, voluntary dissolution where no creditors are affected. So if a corporation wants to dissolve without harming any creditors, it should follow these steps. First is majority board approval and affirmative vote of stockholders. So the board of directors must approve the dissolution. Then at least 2/3 of the stockholders must also agree. Second is at least 20 days notice to the shareholders by personal delivery, registered mail, or any authorized means. So the corporation must inform all shareholders at least 20 days before the meeting where they will vote on the dissolution. Third is publication of meeting notice in a local or national newspaper. The corporation must announce the meeting in a newspaper so everyone is informed. Now is the filing of a verified request for dissolution with Security and Exchange Commission stating first the reason for dissolution. For example, is bankruptcy or retirement. Second is how and why notices were given, so proof that members were informed. Third is names of approving stockholders or members and directors or the trustees. And fourth is the meeting details, the date, place, and the time. And lastly is the proof of publication. For instance, is the newspaper ad. Following are the submission to the Security and Exchange Commission. First is certified copy of dissolution resolution. Second is proof of publication. Third is favorable regulatory recommendation if applicable. Fourth is Security and Exchange Commission approves the request within 15 days provided that there is no withdrawal. So if everything is complete, the Security and Exchange Commission will approve the dissolution within 15 days. Lastly is the dissolution takes effect upon issuance of the certificate of dissolution. So the corporation is officially dissolved when the Security and Exchange issues the certificate. So financial institutions are require a favorable recommendation from the appropriate government agency. Withdrawal request for dissolution. So within 15 days, a verified withdrawal may be filed by an incorporator, director, trustee, or stockholder owning the majority of the shares. So Security and Exchange Commission may do the following. First is declare the request withdrawn. Second is order a joint meeting to decide on dissolution, and lastly is issue appropriate orders. So as an example is a company decides to dissolve but later gets a big business opportunity. So the stockholder withdraw their request before the Security and Exchange Commission finalizes the dissolution. For approval and issuance of certificate, if no withdrawal is made within 15 days, the Security and Exchange Commission approves the request and issues certificate of dissolution. So as an example is a coffee shop chain decides to close after years of declining sale. So since no creditors are affected, the Security and Exchange Commission issues dissolution certificate after 15 days. Next is Section 135, voluntary dissolution where creditors are affected. So when creditors' rights are at risk, a verified petition for dissolution must be filed with Security and Exchange Commission. And these are the procedures to do so. First is majority of the board must sign the petition. So the board of directors or the trustees must first agree to dissolve the corporation. Second is approval by 2/3 of the stockholders or members. So since creditors are involved, at least 2/3 of the stockholders or member must also approve. Next is Security and Exchange Commission sets a deadline for objections, and this may be 30 days to 60 days. So creditors or other interested party can object within this time frame. Next is publication of order once a week for 3 consecutive weeks in a general circulation newspaper. So the dissolution must be publicly announced to inform creditors and other stakeholders. Next is posting of the order in 3 public places for 3 weeks. So the Security and Exchange Commission requires public notices in different locations. Next is after the objection period, the Security and Exchange Commission hears the petition. So the Security and Exchange Commission evaluates any objections and decides whether to approve the dissolution. So if valid, the Security and Exchange Commission renders judgment, orders asset disposition, and may appoint a receiver. So the Security and Exchange Commission may appoint a receiver to handle corporate assets and ensure creditors are getting paid. And lastly is dissolution takes effect upon issuance of certificate of dissolution. So once the Security and Exchange Commission is satisfied, it officially dissolves the corporation. So as an example is a pharmaceutical company legally ceased to exist after receiving the certificate. Contents of the petition for dissolution. So, a petition for dissolution must include the following. First is the reason for dissolution. Second is the details for notice given, such as the form, manner, and the time. And lastly is the meeting details, such as the date, place, and time when the vote was made. So take note that for dissolutions where creditors are affected, Security and Exchange Commission may appoint a receiver to handle corporate liquidation. Next is Section 136, dissolution by shortening corporate term. So, a corporation may voluntarily be dissolved by amending the articles of incorporation to shorten its corporate term. And the procedures are: first, amend the articles of incorporation to reflect the shortened term. The corporation must file an amendment stating the new earlier termination date. Second is submit the amended articles to the Security and Exchange Commission for approval. So the Security and Exchange Commission reviews and approves the changes. And lastly is Security and Exchange Commission approves the amendments and recognizes the dissolution. So once approved, the corporation automatically dissolves when the new terms end. And for the effect of the dissolution, first is the corporation is automatically dissolved upon the expiration of the shortened term without further proceedings. So no additional steps are needed after the new term ends. Next is Security and Exchange Commission does not issue a certificate of dissolution for this method. Since the dissolution happens automatically, no formal certificate is needed. And for the note, first is the new expiration date must be a future date. So the corporation cannot retroactively shorten its term. Lastly is if the proposed expiration date has already passed at the time of the filing, Security and Exchange Commission will not accept the amendment application. So the Security and Exchange Commission will reject an application if the chosen end date has already expired. Section 137, withdrawal of request and petition for dissolution. First is, a written, verified withdrawal must be signed by the same number of incorporators, directors, trustees, stockholders, or members who originally requested for the dissolution. So to cancel dissolution, the same number of people who approve it must sign the withdrawal request. Next is, the withdrawal must be filed within 15 days from the Security and Exchange Commission receipt of the dissolution request. So the company only has 15 days to withdraw its application. Next is the Security and Exchange Commission actions on withdrawal. First is deem the request withdrawn. So if everything is in order, the Security and Exchange Commission cancels the dissolution. Next is direct a joint meeting of the board and stockholders or members to reconsider dissolution. So, if necessary, the Security and Exchange Commission may order another vote on dissolution. And third is issue other appropriate order. So, the Security and Exchange Commission can give further instructions based on the situation. And for petition for dissolution, the withdrawal must be filed before the Security and Exchange Commission publishes the other setting deadline for objections. Next is, if the order has already been published, it's too late to withdraw. Section 138, involuntary dissolution. A corporation may be involuntarily be dissolved by Security and Exchange Commission or upon a verified complaint by an interested party. So, the grounds for involuntary dissolution are the following. First is non-use of corporate charter within the period stated in Section 21 of the Code. If a corporation fails to use its corporation rights, it may be dissolved. Second is continuous in operation as provided in Section 21 of the Code. If a company stops operation without valid reason, it may be dissolved. Third is court order dissolving the corporation. A court may dissolve a company for legal violations or fraudulent activities. Fourth is final judgment that the corporation was fraudulently incorporated. If the Security and Exchange Commission or a court finds that a corporation was created through fraud, it will be dissolved. Forfeiture of assets. If a corporation is dissolved under these grounds, its assets after paying liabilities may be forfeited in favor of the national government upon the Security and Exchange Commission petition to appropriate court. So the government may seize the corporation's remaining asset. As an example is a dissolved company's assets are taken by the government due to tax evasion. The exception is innocent stockholders and employees retain rights to unpaid compensation. So employees and innocent stakeholders or shareholders can still receive what they are owed. Last section under Title 14 Dissolution is Section 139 Corporate Liquidation. First is a corporation remains a legal entity for 3 years after dissolution, but only to the extent of the following. First is to settle legal matters, to close affairs, to dispose property, and to distribute assets. Next is no corporation may distribute its asset except upon lawful dissolution and full payment of debts and liabilities. A company cannot distribute funds to its owner if it still has unpaid debts. So the exemptions are banks are subject to New Central Bank Act, the RA 7653 and Philippine Deposit Insurance Corporation Charter or the RA 3591. So, unlike regular corporation, banks must follow specific liquidation procedures under banking law. For asset distribution rules, a dissolved corporation may transfer its asset to trustees for distribution among stockholders, members, creditors, and other interested parties. Because after dissolution, the corporation's assets are assigned to trustees who will properly distribute them. As an example is a dissolved real estate company appoints a trustee to sell its remaining properties and distribute the proceeds. Next is once assets are transferred, the corporation no longer holds any legal interest in them. After liquidation, the company cannot reclaim any asset. Lastly, unclaimed asset of unknown stockholders or creditors will be transferred to national government. If there are assets that belongs to untraceable stockholders or creditors, the government will take them. For general rule, no corporation may distribute its assets except upon lawful dissolution and full payment of debts and liabilities. A company cannot divide assets among owners unless it has properly dissolved and settled all obligation. For exception, non-stock corporation may have different asset distribution rules. Since non-stock corporations such as charities and foundations have no owners, the remaining asset may go to another similar organization.
Good day, everyone. Now we're going to discuss about Title 15, Foreign Corporations. So this section of the law establishes the rules and requirements for foreign corporations that want to do business in the Philippines. So it ensures that foreign businesses operate legally, protect the rights of Filipino stakeholders, and comply with Philippine laws. Now let's discuss about Section 140, Definition of Rights of Foreign Corporation. So this section only means a foreign corporation is any company formed, organized, or existing under the laws of another country. However, it can only operate in the Philippines if the foreign country where it was established allows Filipino businesses to operate there. So we have prerequisites for this. First is to obtain a license under this code, and second is to secure a certificate of authority from the appropriate government agency. So this requirement ensures fair and reciprocal treatment between foreign and Filipino businesses. Next is Section 141, Application to Existing Foreign Corporations. So this section talks about foreign corporations that were already authorized to do business in the Philippines before the law took effect can continue operating under the existing licenses. However, they must still comply with the updated provisions of this code and other relevant laws. Now let's discuss about Section 142 or application for a license. So to legally do business in the Philippines, a foreign corporation must apply for a license with the Securities and Exchange Commission. They should submit the certified copies of articles of incorporation and bylaws and the translated documents if ever they are in the foreign language. They also, they also should submit a sworn application that includes the incorporation date and term, the principal office address abroad, the resident agent details in the Philippines, the business location of the Philippines, the purpose of doing business in the country, and the list of directors and officers. It should also include the capital structure details, the authorized and outstanding shares, and also their proof of financial solvency. So, when applying for a license to do business in the Philippines, a foreign corporation must submit a certificate under oath from its home country. This certificate must confirm two things: the reciprocity, or the foreign country allows Filipino businesses to operate there, and a good standing, that the foreign corporation is legally recognized and in good status. So if this certificate is in a foreign language, it must be translated into English and certified under oath by the translator. Additionally, the application must include a sworn statement from the company's president or an authorized representative proving that the corporation is financially stable. This statement must list the company's assets and liabilities and be based on financial records from no more than 1 year before the application date. So, foreign banks, financial institutions, and insurance companies must also comply with specific existing laws that apply to their industry. For other types of foreign corporations, the SEC will not accept the application unless the company first obtains approval from the relevant government agency if required by law. Now, section 143, the issuance of a license. Since this section is too long, let me simplify it. So once a foreign corporation completes all legal requirements, the SEC, or the Securities and Exchange Commission, will issue a license allowing it to operate in the Philippines. So the corporation can continue doing business as long as it remains legally recognized in its home country and its license is not surrendered, revoked, suspended, or annulled under Philippine law. The securities deposit requirement, or within the 60 days of receiving the license, the corporation, except banks and issuance companies, must deposit at least 500,000 worth of securities with the SEC. This can include Philippine government bonds, stocks in Philippine companies, and other approved financial instruments. So for additional deposits every year, the SEC reviews the corporation's gross income at the end of each fiscal year. So if the gross income exceeds 10 million, the corporation must deposit an additional amount equal to 2% of the excess within 6 months after the fiscal year ends. If the value of previously deposited securities drops by 10% or more, the SEC will also require the company to replenish the deposit. And if the market value increases by more than 10%, the SEC may allow the corporation to withdraw part of the excess deposit. The collection of profits and withdrawal of deposits, the corporation can still collect interest or dividends from the deposited securities, and if the corporation stops doing businesses in the Philippines, it can apply to withdraw its deposits, but only after or proving that it has no remaining debts or liabilities to creditors or the government. So the SEC will determine the calculation of gross income and any allowable deductions based on its established rules. Now let's proceed to section 144. Who may be a resident agent? So, a resident agent is a representative in the Philippines who handles legal matters for the foreign corporation. So, this agent can be an individual residing in the Philippines with good moral character and financial standing, and a Philippine based corporation in good financial standing. So, the role or the duties of a resident agent is to accept court summons, and legal documents on behalf of the foreign country or the foreign company, and to ensure the company follows Philippine laws. So a resident agent ensures that the company cannot avoid legal responsibilities in the Philippines. Next is Section 145, Resident Agent Service of Process. So before a foreign corporation can receive a license to do business in the Philippines, it must appoint a resident agent. So like what I said before, a resident agent is a person or a company in the Philippines who is authorized to receive legal documents or notices, summons, or court documents on behalf of the foreign corporation. So the key requirements is the foreign corporation must submit a written power of attorney to the SEC, officially designating its resident agent. Second is the corporation must agree that any legal notice or court document served on the resident agent is considered valid as if it were delivered to the corporation's home office. And if the corporation stops doing business in the Philippines or no longer has a resident agent, then legal notices can be served directly to the SEC instead. So this will still be considered valid. So how legal notices are handled? First, if the SEC receives a summons or legal document on behalf of the foreign corporation, it must send a copy by mail to the corporation's home office within 10 days. And the person or the party requesting the legal service must pay in advance for the mailing and processing costs. So, and the resident agent must notify the SEC immediately if they change their address. This rule ensures that foreign corporations remain accountable for legal matters while doing business in the Philippines. Now we have Section 146, Law Applicable. So foreign corporations operating in the Philippines must follow all Philippine laws applicable to domestic corporations except for those that deal with incorporation, formation, and dissolution of corporations, and internal relations among stockholders, members, and officers, since these matters are governed by the laws of the corporation's home country. So this ensures that foreign corporations comply with local business regulations while maintaining their corporate structure based on their home country's laws. Next is Section 147, Amendments to Articles of Incorporation or Bylaws. So this section simply means if a foreign corporation makes changes to its articles of incorporation or bylaws, it must first submit an authenticated copy of the amendments to the SEC within 60 days, and also file it with other government agencies if required. However, these amendments cannot expand or change the corporation's approved business activities in the Philippines. Now, we have Section 148 Amended License. So this simply means if a foreign corporation wants to change its name or expand its business scope, it must apply for an amended license with the SEC. So in some cases, additional approval from government agencies may be required. Let's proceed to Section 149, Merger or Consolidation involving a foreign corporation. So a foreign corporation that is legally doing business in the Philippines can merge or consolidate with a domestic corporation or another foreign corporation if first the Philippine laws allows it, and second is the law of its home country also permit it. So the requirements for mergers and consolidations are if the foreign corporation are merger and consolidation under the Philippine Corporation Laws or Code, it must comply with all legal requirements. And if a foreign corporation is involved in a merger on or consolidation in its home country, it must first submit a copy of the merger or consolidation documents to the Commission within 60 days after it becomes effective, and also file the same documents with other relevant government agencies if required. And if the foreign corporation ceases to exist due to the merger or consolidation, and it was licensed to operate in the Philippines, it must also file a petition to withdraw its license. So this ensures that business transactions are properly documented and that a foreign corporation no longer operates in the Philippines once it has been absorbed in a merger or consolidation. We're now on section 150, doing business without a license. So, foreign corporations that transact business in the Philippines without a license cannot file lawsuits or participate in legal proceedings in Philippine courts. Also, it can be sued by other parties under Philippine law. So, this section discourages unregistered foreign companies from operating in the country. For the revocation of license, or Section 151, the SEC may revoke or suspend a foreign corporation's license if it fails to submit annual reports or pay fees, fails to appoint or maintain a resident agent, fails to update its records after major changes, submits false or misleading information, fails to pay taxes or government fees, engage in unauthorized business activities, acts as an agent of another unlicensed foreign corporation, and commits any other violation that makes it unfit to operate. Section 152, Issuance of Certificate of Revocation. So when a foreign corporation's license is revoked, the SEC will issue a certificate of revocation and notify the relevant government agencies. It will also send a mail or a copy of the revocation to the corporation's registered office in the Philippines. We are now in our last section for this topic, section 153, withdrawal of foreign corporations. So a foreign corporation may voluntarily withdraw from the Philippines by filing a petition for withdrawal with the SEC. So before withdrawal is approved, the corporation must first settle all outstanding claims and liabilities, second, pay all taxes, assessments, penalties that is due to the government, and third is publish a notice of withdrawal for 3 consecutive weeks in the Philippines. So this section ensures that the corporation has no remaining obligation before officially exiting the Philippine market.
Good afternoon, everyone, especially to you, sir. So we will now be proceed to the next topic, which I will be discussing. It's about investigation, offenses, and penalties. So Section 154, which is the investigation and prosecution of offenses, ang gagawin ko na lang is I am going to explain it directly. So ang sinasabi rito sa section na ito is that ang commission, they have the authority to investigate those possible or alleged violation of this code. And with that, pwede rin nilang i-publish ang mga kanilang findings, opinions, advisories, or information na may kinalaman sa mga violations na yun that may be relevant to the public. And as long as it adhere to the Republic Act of number 10173, or also known as the Data Privacy Act of 2012. However, bago nila dapat i-publish ang mga information na yun, they must go or they must give notice to or coordinate with proper regulatory agencies. So moving forward to the next section, which is the section 155, Administration of Oaths, Subpoena of Witnesses and Documents. Ang sinasabi lang dito sa section ito is that the commission, through its designated officers, they have the authority to first administer oaths and affirmations. Second, issue subpoena, which means that it is a general formal written order of the court that requires a person to attend in a proceedings such as hearings, and subpoena duces tecum, meaning it requires the witnesses in the proceedings to bring or produce documents and other evidences. The third one is to take testimony in any inquiry or investigation. And lastly, um, or the fourth one is to perform an act na kailangan sa proceedings or sa investigation. So the section 156, which is the cease and desist orders, is that kung yung SEC or yung commission ay may reasonable basis that can prove that a person violated or is about to violate the code, rule, regulation, or yung mga order ng commission, pwede nilang directly sabihan yung tao na yun na to stop from committing those actions that can constitute violation. Additionally, pwede rin silang mag-issue ng cease and desist order ex parte, meaning ito yung mga legal order that issued by a court which requires a person or a party to immediately stop a specific action without a prior notice to the person or the party, which can cause a significant, imminent, and irreparable danger. Yung mga danger na hindi mo na mababawi and um, to the safety of public and welfare. So prior to that, yung pag-issue ng ex parte can only be valid for a maximum period of time which is 20 days. Or pwede siyang maging permanent in case without any prejudice to the order after the due notice. So moving forward to the next section, which is the section 157 or the contempt. Any person who without justifiable cause fails or refuses to comply with any lawful order, decision, or subpoena issues by commission shall, after due notice and hearing, be held in contempt and fined in an amount not exceeding 30,000 pesos. So ang sinasabi sa section na ito is that if a person without a justifiable reason fails or hindi sumunod sa lawful order, decision, or subpoena which issues by commission after the due notice, pwede siyang maging liable in contempt at pwede siyang pagbayarin ng multa ng amount 30,000 pesos. So additionally, if ever na hindi pa rin siya sumunod after being fined by commission to clear such violation, pwedeng mag-impose ang commission ng daily fine na 1,000 pesos until the order, decision, or subpoena is complied with. The next section is the section 158, which is the administrative sanctions. So in this section, if the commission found out after the due notice na may na-violate to any of the provisions of this code, rules, and or regulations, pwede nilang impose ang following sanctions. So first, they can impose a fine from 5,000 to 2 million pesos and additional 1,000 pesos if they continue the violation, but not more than 2 million pesos. Second, pwede rin silang mag-issue ng permanent cease and desist order. Third, suspension or pwede nilang bawiin yung certificate of incorporation. And lastly, pwede nilang i-dissolve mismo yung corporation and forfeit their assets. Moving forward to the next section, which is the section 159, unauthorized use of corporate name. So, ang sinasabi lang dito sa section na ito is the unauthorized use of corporate name, which can be punishable at pwede silang pagbayarin ng multa from 10,000 to 200,000 pesos. The next section is the section 160 or 160, which is the violation of provision, disqualification provision, penalties. When, despite the knowledge of the existence of a ground for disqualification, a director, trustee, or officer willfully holds office or willfully conceals such disqualification, such director, trustee, or officer shall be punished with a fine ranging from 10,000 pesos to 200,000 pesos. So ang sinasabi lang dito is this section talks about the disqualification, which is despite the knowledge ng director, officer, or trustee na disqualified na sila sa position nila, pero sinasadya nilang magstay or manatili sa office na yun and conceals their disqualification, they can be punishable at pwede silang pagbayari ng multa which is 10,000 to 200,000. And at the decision of the court, they can be permanently disqualified sa position nila sa corporation. Additionally, if this violation is serious or malaki yung impact niya sa public, pwede madagdagan ang penalty nila from 20,000 to 400,000 pesos. So according to the section 26 of the revised corporation code, a director, officer, or trustee shall be disqualified in any of the corporation if within the 5 years of election or appointment sa kanila ay they're convicted by final judgment such as an offense punishable by imprisonment. Second, if they violated the code. Third, and violating the RA number 8799, also known as the Securities Regulation Code. Second, if they were found liable for any offenses katulad ng acts, fraud acts, and lastly, if they are being convicted by foreign court for such violation that I have mentioned earlier. So the next to be discussed is the section 161, which is the violation of duty to maintain records to allow their inspection or reproduction penalties. So ang sinasabi lang dito sa section na ito is that a corporation must be responsible for keeping a corporate records, and if ever na nag-fail sila to do so for maintaining corporate records to comply with section 45, 73, 92, 128, 177, and other pertinent rules and provision, they can be punishable at pwede silang pagbayarin ng multa from 10,000 to 200,000 pesos. And at that decision of the court, taking into consideration the seriousness of the violation and their implications. So, additionally, if ever yung violation nila ay malaki yung impact niya sa public, pwede pang tumaas yung penalty nila from 20,000 to 400,000 pesos. So for the next section, which is the section 162, or the willful certification of incomplete, inaccurate, false, or misleading statements or reports, penalties. Any person who willfully certifies a report required under this code, knowingly that the same contains incomplete, inaccurate, false, or misleading information or statements, shall be punished. So ang sinasabi lang dito sa section na ito is that kapag if a person kapag nag-certify siya ng report with them being fully aware that it contains incomplete, inaccurate, false, or misleading information, they can be punishable at pwedeng pagbayarin ng multa from 20,000 to 200,000 pesos. So likewise, kapag yung violation nila na yun can cause significant injuries to the public, the auditor or yung taong responsible sa violation na yun ay madadagdagan pa yung multa niya from 40,000 to 400,000 pesos. So going forward to the next section, which is the section 163, or the independent auditor collusion penalties. So an independent auditor, ang sinasabi lang dito is that kapag nagkaroon ng agreement or nakipagsabuatan yung independent director na yun with the director ng corporation or any of the representative to certify such report knowingly na it contains inaccurate, incomplete, and false information, pwedeng maging liable yung auditor na yun na bayaran ang multa from 80,000 to 500,000 pesos. So just like the other penalties, kapag yung fraud na yun ay can cause serious impact to the general public, pwede pang tumaas yung multa ng auditor na yun from 10,000 to 600,000 pesos. I mean from 100,000 to 600,000 pesos. So moving forward to the next section, which is the section 164, or the obtaining corporate registration through fraud penalties. So ang sinasabi lang dito is that if a corporation is formed through fraud or it does not follow the proper ways, can be punishable at yung mga involved sa corporation na yun ay magiging responsible sila sa fine or multa from 200,000 to 2 million pesos. So if such violation can cause significant impact to the public, the penalty can increase from 400,000 to 5 million pesos. The next section is the section 165 or the fraudulent conduct of business penalties. So, ang sinasabi rin dito is that if an entity conduct its business through fraud, magiging liable ang corporation na yun with the punishment at magbabayad sila ng multa from 200,000 pesos to 2 million pesos. And kagaya nung sa section 164, kung yung violation na yun can cause significant impact to the public, pwedeng madagdagan o mag-increase yung multa ng corporation na yun from 400,000 to 5 million pesos. So the next to be discussed is section 166, the acting as intermediaries for graft and corrupt practices penalties. So this section talks about the penalties of a corporation kapag they used fraud or they committed such fraud kagaya ng concealing or hiding graft um, and corrupt practices. They can be punishable at liable sila na magbayad sa multa from 100,000 to 500,000 pesos. Additionally, it is proved na yung directors, if it is proved na yung directors, officers, employees, agents, or representative that they engage in such actions at walang ginawang remedy yung corporation, such as to safeguard transparency and to install policies, code of ethics and procedures against graft and corrupt practices, pwedeng gamitin yun as a form of evidence for a corporate liability. So moving forward to the next section, which is the section 167, engaging as intermediaries for graft and corrupt practices penalties. So ang sinasabi lang dito is that if yung corporation is nag-appoint ng intermediaries or like a middleman to engage in graft and corrupt practices for the benefits and interests of a corporation, they can be punishable at pwedeng pagbayarin ng multa from 100,000 to 1 million pesos. The next section is the section 168, tolerating graft and corrupt practices penalties. So dito naman, if yung director, trustees, or officers is being aware of such action like graft and corrupt at wala silang ginawa to report those actions committed by the director, fellow director, officer, or trustees of a corporation and they tolerated it, pwede silang maging liable sa punishment at pwede silang pagbayarin ng multa from 500,000 pesos to 1 million pesos. So the next to be discussed is section 169 or the retaliation against whistleblowers. So a whistleblower refers to any person who provides truthful information relating to the commission or possible commission of any offense or violation under this code. So, basically, yung whistleblower, sila yung mga taong who provides truthful information regarding the commission or possible commission of a violation. So, ang sinasabi rito is that if other who is being part of the corporation have the intention to take revenge against the whistleblower, like tinanggal nila sa trabaho, tinakot nila, or pinahirapan nila inside the company, those person at the decision of the court can be liable, pwede silang maging liable sa punishment at pwede rin silang pagbayarin ng multa from 100,000 to 1 million pesos. So moving forward to this section 170, other violation of the code, separate liability. So violations of any other provisions of this code or its amendments not otherwise specifically penalized therein shall be punished by a fine or not less than 10,000 pesos but not more than 1 million pesos. So, ang sinasabi lang dito is that if there are other violations to the provisions of this code, pwedeng maging liable yun sa punishment at pwedeng pagbayarin ng multa from 10,000 pesos but not more than 1 million pesos. Additionally, if such violation is committed by a corporation, pwedeng ma-dissolve mismo yung corporation na yun in a proper proceedings. However, kahit na na-dissolve na yung corporation na yun, pwede pa rin kasuhan yung mga taong responsible roon, like yung mga directors, officers, or trustees. And the liabilities of these responsible persons are separated from any other administrative, civil, or criminal liability. So these are the last sections that I will be discussing. The first one is the section 171, liability of directors, trustees, officers, or other employees. So ang sinasabi dito sa section na ito is that if yung corporation mismo ang nag-commit ng violation, they can be charged for such penalties as at the decision of the court. Ang pwedeng maging responsible ay yung mismong corporation, yung mga directors, trustees, stockholders, members, officers, or yung mismong employees ng corporation na yun. The last section is the section 172, liability of aiders and abettors and other secondary liability. So, in such case na may naging third party na tumulong, nag-encourage or nag-command to violate such code, they can be punishable at pwedeng pagbayarin ng multa not exceeding sa na-impose mismo sa gumawa ng act na yun or yung mismong nag-commit ng violation na yun. So, that's all. That's all my part. Thank you.